We conducted a survey among people of our age to gauge our previous understanding of pardons and the Pardons Board. We concluded that there isn't enough public awareness of this subject amongst the general public. 64.8% of the respondents claimed that they know what a pardon is, but when asked, only 11.27% could accurately name the members of the Pardons Board. Furthermore, 56.3% expressed that they had a limited understanding of the Pardons Board's roles and responsibilities. Here's a brief introduction on the current law on pardons. Pardons in general can be defined as the head of state's ability to postpone, suspend, or cancel a convict's sentence. Here in Malaysia, pardons are provided by Article 42, Clause 1 of the Federal Constitution. For offences committed in the Federal Territories, the Yang di-Pertuan Agong exercise the power of pardon. Meanwhile, the rulers or Yang di-Pertuan Negeri wield the power of pardon when it comes to offences committed in their respective states. According to Article 42, Clause 5 of the Federal Constitution, the Pardons Board consists of the Attorney General, the Chief Minister of the State or the Federal Territories Minister, and up to 3 more members appointed by the ruler or Yang di-Pertuan Negeri. When can a pardon application be made? One can only apply for a pardon after he has exhausted all other legal processes, such as appeals to higher courts and judicial review applications. The power of pardon is known to be non-justiciable, meaning that the decision to pardon or not is not subject to judicial review. Judicial review is when a court reviews the decision-making process of a public body. Various federal court cases such as Kapau Singh and Sultan of Selangor, Juraimi bin Husin and Lembaga Pengampunan Negeri Pahang, Dato Sri Anwar Ibrahim bin Ibrahim and Mod Khairul Azam bin Abdul Aziz have taken a firm stance on this issue. Lastly, must the Pardons Board advice be followed? According to Article 42, Clause 4, Subclause B of the Federal Constitution, the Sultan or Yang di-Pertuan Negeri acts on advice of the Pardons Board when exercising the power of pardon. As for federal territories, Clause 4A allows Parliament to make laws extending or limiting the Yang di-Pertuan Agong's power of pardon. However, no law has been made under this clause. When read together with Article 40, Clause 1, the Yang di-Pertuan Agong shall act on the advice of the Cabinet when exercising the power of pardon. We had the privilege of conducting interviews with renowned experts on Malaysian constitutional law, Mr. Muhammad Hanif Kadri Abdullah, Dr. Nik Ahmad Kamal Nik Mahmud, and Mr. Andrew Khoo, who have generously shared their extensive knowledge and experience and shared invaluable insights into the current state of constitutional law in Malaysia. Several federal court cases have demonstrated that the discretion lies solely with the Yang di-Pertuan Agong. As a result, the decisions made by the Pardons Board are not subject to review. This was evident in Dato Sri Najib's petition to review his conviction, where his appeal was dismissed due to the non-justiciability of pardons. Concerns have been raised regarding the potential political influence on the composition of the Pardons Board, particularly in Dato Sri Najib's case. These concerns arise from the fact that the current government does not have a Federal Territories Minister, with the Federal Territories Ministry currently operating under the Prime Minister's Department. However, if Dato Sri Anwar were to declare a conflict of interest due to the political reasons and step down as a representative of the Federal Territories Ministry, it would render the board unconstitutional. According to the Constitution, there must be a representative from the Federal Territories Ministry. Thus, the composition of the Pardons Board for Dato Sri Najib's case is considered constitutional. It is worth noting that Dato Sri Najib's case presents a unique situation. It is the first time an individual is seeking a pardon for one conviction while still having other active cases. Typically, pardons are only pursued once all court proceedings have concluded. Moving on to the current problems and potential reforms, Regulation 113 of the Prisons Regulation 2000 is deemed unconstitutional as it allows convicts to apply for setting aside both the conviction and sentence. However, Article 42, Clause 1 of the Federal Constitution specifies that a pardon only sets aside the sentence, with no mention of the conviction. The term conviction should be removed as it exceeds the legal authority. Furthermore, there is a need to establish a clearer time frame for considering pardon applications. Currently, there is no specified time frame, leading to a significant variations in processing times. Mr. Hanif Kadri shared a personal anecdote of a convict who received no response to their pardon application for 12 years. The convict's lawyer challenged this lack of response, arguing that it was unconstitutional. However, the court ruled that the matter was not justiciable as the prerogative of mercy rests with the discretion of the Yang di-Pertuan Agong. In addition, the system of checks and balances is insufficient. Due to the non-justiciability of pardons, the only avenues for accountability are public and political pressure. However, the federal court firmly asserts that this issue is not subject to judicial review. For instance, the membership of the Pardons Board cannot be reviewed by the judiciary. Lastly, there is a lack of public awareness. Yes, the public may be aware of the existence of the Pardons Board, but generally speaking, there is confusion regarding its functions and features. It is crucial for lawyers, academics, and students to make efforts to clarify these aspects to the general public, as it is important for the public to be aware of their rights.